And here we go.
Good morning, everybody, and welcome to program 9.3, The Gig is Up, or is it? The Future of the Gig Workplace. You can tell us from all the other panels on the gig workplace because we use the word twice in there, but despite the unfortunate title, we're going to try to have an intelligent discussion about issues affecting contingent workers. My name is David Ruiz Cameron, and I want to introduce our panelists. We're joined today by Josh Adams of the Gilbert and Sackman law firm in Los Angeles, and also Tom Lenz of the Atkinson Andelson firm in Pasadena. Unfortunately, our fourth panelist, Amy Silverman of Region 21 of the National Labor Relations Board, was unable to join us, but we're going to soldier on and think of her inspiring us to do this panel. Our agenda for today is as follows. I'm going to present a short overview on employees and independent contractors, and then our panelists are going to present some recent developments focusing on the independent contractor versus employee issue. All of us are going to present some thoughts about the future, and then time permitting, we want to take some questions and answers, although we're going to attempt to monitor the participant column once we get into the developments area and try to answer your questions as they come up so that hopefully we can have some interaction. And then along the way, the various recent developments have citations to them on the slides, but other data, in particular, data that we get from the current population survey published by the Bureau of Labor Statistics and some other sources are cited in the bibliography. You can find those at the end of the PowerPoint presentation. So let's get started. I think we should talk about some terminology first. Who's a gig worker? And the terminology varies with the culture and sometimes the country. A lot of academics use the term contingent to describe gig workers. In international parlance, the term precarious worker is sometimes used. For our purposes today, by talking about gig workers, we're referring to anyone among the roughly 31% of US workers who fall into one of these following categories: independent contractors, which is our focus here, leased employees, part-time workers, seasonal workers, temporary workers, and of course many others that are not considered core employees of the organizations with which they're affiliated. And if you want further information about the definition, I think we're indebted to Professor David Weil for the 31% figure, and his book is cited in the bibliography. The use of independent contractors has been and remains quite significant in the US economy, if it's not exactly growing as much as people might think. In what I call the PU or pre-Uber era, the data that the current population survey produced for the period 1995 to 2005, in that decade, the percentage of the workforce that could be considered independent contractors rose from 6.7 to 7.4% of the workforce. That's over 10 million workers. But in the Uber era, which, if you'll pardon me, really begins in 2009 when Uber shows up, but certainly persists throughout the 12-year period measured in the current population survey, there was a slight decline in the percentage of the workforce that could be characterized as independent contractors, but their absolute numbers increased from 10.3 million to 10.6. So by any measure, that's a lot of folks. We think it's worth noting that in the CARES Act, which provides for pandemic unemployment assistance, or PUA, that it was reported that as recently as May 16th, and there's more data in now, but as of May 16th, 36% of all PUA claims were made by gig workers. That's a huge percentage by any measure, we think. With respect to one of the legal issues that we're talking about today, the classification or misclassification of workers as employees or independent contractors, this affects all the rights of a federal and state character that you can think of that protect employees in the workplace. And so in addition to the alphabet soup of federal statutes that are listed here and state labor codes and workers' comp schemes and wrongful termination, et cetera, just today we were reminded by the US Supreme Court, which issued a pair of landmark decisions declaring that lesbian, gay, transgender, and bisexual and queer workers are considered to be protected by Title VII of the Civil Rights Act of 1964. If they are discriminated on that basis, that's considered discrimination based on sex. That's the Bostock case and Altitude Express versus Zarda, which were just issued a few hours ago by the Supreme Court. If you're not considered an employee, you don't have access to those protections under Title VII or any of the others that are listed here. So who's an independent contractor? Over the years, 3 distinct legal tests have emerged, and I'm indebted to my co-author, Professor Ken Dow-Schmidt, for summarizing these, and there's a citation in the bibliography to where you can find it. But the most common test, the common law agency test, or right of control, is the one that's most frequently relied upon under different statutory schemes and by various federal and state agencies. And I think it's just noteworthy here for the fact that as many as 20 factors appear in the common law or right of control test, and that the burden is generally on the employee or the agency to establish that there's an employment relationship other than an independent contractor relationship. The economic realities test, which is commonly associated with labor protective legislation like the Fair Labor Standards Act, presumes that there's an employment relationship if there's economic dependency, or the economic reality is that the worker is dependent upon the employer, but that's used in a minority of legal schemes that affect workers' rights. And then the emerging test that's becoming more popular across the country is the ABC test, which has been adopted in whole or part by 36 different states, most prominently California, Illinois, Oregon, and Massachusetts, not by New York, not by the District of Columbia. Although it is common among some of the states that have adopted this ABC test that they haven't adopted it all. They may adopt Part A and Part B or Part C. So what am I talking about? The ABC test says that the agent or worker in question is presumed to be an employee unless the principal or employer is able to show 3 things, A, B, and C. A, that the individual is free from direction and control, both under contract and in fact. In addition, that her services are performed outside the usual course of the employer's business, and that the individual is customarily engaged in an independent established business of the same nature as that is at issue. And again, that puts the burden on the purported employer to show that the employee is an independent contractor, and you've got to satisfy all 3 unless it's a jurisdiction that's only adopted 2 of the 3, which a number have. So that brings us to talking about recent developments under the National Labor Relations Act, a little bit briefly under the Federal Arbitration Act, in California, where all of our panelists are from, and then we want to talk a little bit about some developments in other states. So with that, let's turn to talking about the first case, and I believe, Josh, you're up first. Thank you.
Thanks, Chris. So just a touch more on my background, just so you understand, we've got some nice perspectives on this panel. I'm at Gilbert and Sackman in Los Angeles. We primarily represent labor unions. We also do significant wage and hour litigation, and I personally, as a part of my practice, have represented a lot of worker centers, including ones that have focuses on Amazon and on Walmart. So very much the employers who have the employees who fall under the gig economy definition posed by Chris in the beginning. And I think at the outset, it's also nice to say that we have a high stakes legal conversation on this panel. For the labor unions that I represent, the question of whether someone is an independent contractor is an existential question. Unions will engage in multi-million-dollar organizing campaigns with really high stakes that have this predicate issue, which if it goes one way or the other, means that they can organize employees or not. And on the other side, you have companies whose entire livelihood, like Federal Express or Super Shuttle, which I'll be discussing, are based on the independent contractor model. So we have parties with very vested interest that they're really willing to fight over. And I think it's interesting that with such high stakes for the parties that are involved, we also have some difficulty and clarity in the law, which is implied, I think, by the different tests that are at issue here, but particularly under the National Labor Relations Act. So under the National Labor Relations Act, the focus that the board is looking at and the courts applying the National Labor Relations Act are looking at are the second restatement of agency law and a Supreme Court decision which favorably cites to that, called United Insurance Company of America. And I loved reading this original US Supreme Court case from 1968 because it sort of described the problem that we have at the present day with clarity. Here's a quote from the case. The case says, "There are innumerable situations which arise in the common law where it is difficult to say whether a particular individual is an employee or an independent contractor, and these cases present such a situation." So that was finding debit agents to be employees of an insurance company. They did things like collect premiums from policyholders, prevent lapses of policies, and sold some new policies. And in deciding that case originally, you would hope that the foundational case would help us a little bit, but here's what it says. It says, "Here, the least that can be said for the NLRB's decision is that it made a choice between two fairly conflicting views, and under these circumstances, the Court of Appeals should have enforced the board's order. It was error to refuse to do so." So this concept of two fairly conflicting views is really, I think, a fair statement of what's going on as we find in this original case and as parties evaluate the restatement, which has, by the way, 10 non-exhaustive factors. You'd think that 10 factors would be enough, but in fact, the 10 factors are non-exhaustive. And so as we get to the present day, the Super Shuttle case, that case was, Super Shuttle is a shared ride vans company that operates under a franchise model. There, the board determined that they were independent contractors. But what we see here is in part the change in the law. The earlier case that this case overturned was called Federal Express. That one had a Democratic majority. Super Shuttle has a Republican majority. You see how when you have these different factors involved and you have different jurisprudential philosophies and also different groups which have different levels of power based on politics can really come to different conclusions. And one of the key issues within those 10 factors in the restatement, or not necessarily within it, but implied within it in the jurisprudence, is this idea of entrepreneurial control or entrepreneurial opportunity, excuse me. And that's what the Federal Express case from 2014 under a Democratic majority had said. And they said, look, you're applying this entrepreneurial opportunity without actual evidence of it. We think it's a theoretical concept, and therefore we want to limit it. It's worth noting that the DC Circuit refused to enforce that decision by the board. And then when we get to Super Shuttle, it really gives the new board an opportunity to reevaluate this. And then overturning Federal Express, they said that the 2014 board had failed by, quote, severely limiting the significance of entrepreneurial opportunity. And at the same time, though, to just give you a sense of the continuing lack of clarity, this board also says that it will consider all of the common law factors in the total factual context of each case, and treating no one factor or the principle of entrepreneurial opportunity as decisive. So it's very interesting that we have this jurisprudential philosophy of entrepreneurial opportunity, which has really become so important, which is not listed as an express factor in the restatement, but is still taking on a much more important role. And so I think with cases like this, it's important to dive into the facts to try and see which facts are most key and what does entrepreneurial opportunity really mean. And in the Super Shuttle board case, what the board found persuasive was that the Super Shuttle franchisees could generally choose where they work. They can generally decide whether to accept a ride or not. They chose their hours of work. They paid a flat fee to Super Shuttle, but they were able to collect income above this amount. So there was an opportunity there that they could seize as entrepreneurs. It was also important that the franchisees owned or leased their vans and could do what they wanted with them. They paid gas, all related costs. I think of particular note for the gig economy, the NLRB found significant autonomy and no supervision, and this is the important part, even though there was a franchise agreement dictating many, many terms of the work for supervision. It included training, it includes the appearance of vehicles and drivers, and it also restricts them from working for Super Shuttle's rivals. The NLRB majority in Super Shuttle also discounted the use of the Nextel dispatching system. So this is how you get rides under Super Shuttle. You get it through a single dispatch system. And the NLRB did not find that to be persuasive in the sense of it being representative or indicative of employee status. And this is because this was part of the franchise services agreement with Super Shuttle. They thought that you had an agreement to perform these duties, but otherwise you were free to act outside of that relationship with Super Shuttle. And it also discounted, and this I think is another important point from conflicting or competing jurisprudential philosophies, that the franchisees were economically dependent on Super Shuttle for their livelihood and had no leverage to negotiate business terms with Super Shuttle. They discounted those concepts. So a couple other facts that I just think are worth noting, which is that the Super Shuttle majority found that it was persuasive or they thought that this was indicative of employee status, but not significant enough to overturn the ultimate finding of independent contractor status, which is that there was no particular skill involved in driving. We'll see that theme going on in other cases. And also another important point, the driving duties were part of Super Shuttle's regular business, but that factor wasn't significant enough to indicate that they were employees.
Sticking with the theme of misclassification of drivers, we're going to ask Tom to talk about the next case and, of course, comment on Super Shuttle if he wants to, which is actually an advice memo from the NLRB's General Counsel.
Thank you, Chris. And good morning, everyone. I'm Tom Lenz. I'm a management side attorney with the Atkinson Andelson firm. I work from Pasadena, California, and frankly, all over the West. I also teach at USC Law School. To be back in the LIRA annual meeting to present. And I'm going to talk about Uber to start off with. And of course, who has been more in the focus on independent contractor issues and misclassification than Uber and Lyft? We have here a National Labor Relations Board advice memo. And as I learned in my days at the board before private practice, advice memos carry incredible weight within the agency. They are not published decisions as such where there's been litigation, but they do reflect a policy choice within the agency as to how to handle a particular issue. If you're not familiar with how advice memos arise, it's either usually by directive from Washington, D.C., or because of a significant issue determined by the region that a matter is sent to headquarters in Washington, D.C. For a determination how to proceed. Do they dismiss the case or do they proceed on it to litigation or settlement? And in a world where Uber, Lyft, other gig economy businesses are facing scrutiny, and in the wake of the Super Shuttle decision, the board, its division of advice, took up this issue of alleged misclassification involving Uber with relation to Uber and Uber Black drivers. And in the theme along the lines of Super Shuttle, as a matter of internal policy, the board said that this entrepreneurial opportunity factor is going to carry significant weight in that determination of whether individuals are in fact employees or, as alleged by the business, independent contractors. And this somewhere business in some parts of the country, like California where I am, businesses are scratching their heads because you've got such a disparity in standards that it makes it hard to know what is the applicable rule. But if your business model is dependent upon use of independent contractors, or at least alleged to be independent contractors, and you can show that the people working for you are actually free to choose when and where they work and to work for others, not just you, this is something that can give you an out, at least under federal law. So businesses that are looking at this issue, that are using this sort of model, are rejoicing about Uber and this entrepreneurial opportunity factor. But I believe this is going to be one of the political footballs that we see in NLRB law, where in a different administration at a different time, the board could very easily choose to go a different way. The tides move frequently on these issues. And if you follow the board over the years, you know that what may be the rule of law today could be completely different 4 or 5 years from now.
Thanks, Tom. I'm going to move on to the next case, Velox Express, and present it very briefly, picking up on the theme that Tom mentioned. Different administrations make appointments to the general counsel position and to the National Labor Relations Board that may cause swings in the board's positions. And during the Obama administration, the prior general counsel took the position that it could be an unfair labor practice, an independent violation of the law all by itself if an employer intentionally misclassified employees as independent contractors. And it was widely expected that the Obama NLRB would agree with that. That board didn't get a chance to make a decision, but in the Velox case, the Trump board held that such misclassification of employees is not an unfair labor practice. Now, I think it's worth just pointing out briefly that the finding of an unfair labor practice requires the board to implement what are called make-whole remedies. The make-whole remedies don't punish anybody. There's no punitive damages. There's no jail at the NLRB for putting someone in incarceration for intentionally violating the law. A make-whole remedy would call for a cease and desist order, the posting of a notice that says we violated the law and we're not going to do it again, and other make-whole remedies such as back pay and giving the pay and benefits on a retroactive basis to people that have been misclassified. But the current law is that is not a violation of the National Labor Relations Act, so there would be no remedy of any kind for misclassification if it turns out to have been wrongly carried out by the employer. So with that, let's move on to the next case where that issue also comes up, and Josh can elaborate on that.
So just continuing the thread from Chris's comments, it's a really interesting question as a matter of policy, whether you're going to have an independent standalone violation for misclassification in an area of the law where, as I indicated earlier, there are just an incredible number of factors. You have evolving law. And, I think one of the things that the present board has been sympathetic to, and I wonder whether a Democratic board, majority board will be sympathetic. It's just that the law has so much flux in it that it's very difficult for employers to be able to nail this perfectly and to have some clarity with respect to their business practices. And the intermodal bridge transport case, I think, is a good example of where an employer was ended up getting it wrong, but you'll see, as in other cases, you have facts which are pointing in opposite directions. So in this case, the board did find that there were employees under the super shuttle analysis. I think that in itself was a just for the purposes of stability in the law, I thought it was nice to see that. But again, you see the focus on entrepreneurial activity being a really key part of this. And here, Intermodal is a logistics company. Here you found the drivers, they thought that they had little opportunity for economic gain or loss. And the trucks and the truck routes were really determined wholly by the dispatch system. Employees had some chance to choose when they were going to work and the shifts they were going to work on, but they didn't own their trucks. And they may have leased them from the employer. But the dispatcher really controlled the flow of the driver's work for their entire shift. And you can contrast that with Uber and Lyft, for example, where Uber and Lyft employees can shift between Uber and Lyft. In one 5-minute period, they could be working for Uber, and another one they could be working for Lyft, and it's their own cars. So it's also interesting, in a lot of these models, we don't see direct supervision, just because they don't they don't need direct supervision because things are controlled either by an app, and the app, or in the case of Super Shuttle, a franchise model which provided a lot of guidance that normally would be employer provided. So, but in any event here, unlike Federal Express, for example, the drivers didn't own their rights. They didn't have a proprietary interest in their routes. They couldn't sell and transfer their routes, and they also couldn't hire employees to work in their place in a route. This case also affirmed the holding of Velox, that a misclassification by itself is not a standalone unfair labor practice under the National Labor Relations Act.
Thanks, Josh. I want to move on briefly to present in short order a case decided a couple months ago. Go ahead, Tom.
Chris, Tom, could I have some time to comment on the last slide?
Go ahead. Absolutely.
Yeah, absolutely. The whole theory about misclassification being an independent unfair labor practice was something that came up first in one of my cases a couple of years ago, Pacific 9 Transportation. And I mentioned advice memos a few minutes ago, and I would commend to you for reading and for consideration in a future administration the advice memo in Pacific 9 Transportation. Again, I represented the business, and the business had drivers who leased trucks, drivers who principally relied upon Pacific 9 Transportation for their work, for their income, and the board took the view that based upon the circumstances of that case, those individuals were misclassified, and that misclassification was, at the direction of DC Division of Advice, an unfair labor practice. That case settled. So intermodal that Josh talked about ended up being the first litigated case on that issue after Pacific 9's case went away. So this is, again, an issue that I think will resurface depending upon who's in charge in Washington at the NLRB.
Josh, anything else?
No, thanks. I second everything Tom said. This football, we're going to be playing with this football for a while.
Yeah, it looks like it. Briefly, I wanted to move on to the fifth case and talk about New Prime versus Oliveira, which was decided in January of this year by the U.S. Supreme Court. It's the subject of other panels at the LYRA conference, and you may be familiar with it from your other work, about the strong preference that the Supreme Court has expressed in interpreting the Federal Arbitration Act that pre-dispute mandatory arbitration agreements should be enforced, and that there's a preemptive effect on state law. And we in California have seen the Supreme Court a couple times wag their finger at our Supreme Court to say that these agreements need to be enforced, which effectively take employees' litigation for discrimination and other claims out of the courts and into arbitration. The other development that has taken place alongside that in more recent years is that an arbitration agreement can include a class action waiver, meaning that the employee can neither bring an action as a class action on behalf of similarly situated employees in court, and they can't do it in arbitration either. So what you have are individual claims being litigated, if anywhere, in arbitration. There's an exception for transportation workers in the Federal Arbitration Act, and it was reaffirmed a few months ago by the Supreme Court, that under that exception, truck drivers can't be forced into arbitration, whether they're employees or independent contractors. So that's an important twist. It doesn't apply to everybody in the workforce, but we have been talking about drivers, and so that definitely is an issue that can come up from time to time. I don't know if either of our panelists wanted to comment on New Prime before we got back to wage and hour matters. Very good.
Very good.
Move on to number 6 and get into the meat of some recent issues in California and ask Tom if he'll present these two matters.
Thank you, Chris. one of the big issues in California has been a case which many practitioners dispute the name of. Some call it Dynamex, but I'm told the actual pronunciation is Dynamics. And in the Dynamics case, there was wage and hour litigation which wended its way to the Supreme Court of California, and there was an issue of a misclassification, and the Supreme Court of California decided that as a matter of law in the state, for purposes of wage and hour, they would use the ABC test going forward. And so this was new information for a lot of people in California. And for the better part of a year, you had a lot of haggling over what this test was, who it applied to, how it applied, and so forth. But bottom line, you had a lot of people scared about I think, significant change, at least scared on the business side, this very significant change in moving from, say, a restatement view of independent contractor status to one which is very strictly controlled by the three factors that Chris outlined earlier. So, if we harken back to slide number 9, Dynamics says that an individual is going to be considered an employee rather than an independent contractor only if the business can prove all three of these factors. The individual is free from direction and control, both under contract and in fact. So this is somebody who is really in business for themselves and makes their own decisions, what to do, how to do it. Really in summary. And then factor B, which is, I think, the biggest hurdle for everyone, services performed outside the usual course of the employer's business. So if you are a trucking company and you hire truckers, you're going to be out of luck on factor B. If you are an office and you hire a plumber to think, that is considered the garden variety example of how to satisfy factor B. It's not something you normally do because in your office you're an insurance company or something else and you don't do plumbing. Factor C, an individual is customarily engaged in an independent established business of the same nature as that at issue. So I would say, do they really hold themselves out as a business? Do they have a location, a license, an identity, a business card, something that truly distinguishes them? If you can't satisfy all three of these factors under the ABC test, under Dynamics, you're out of luck in claiming this person is an independent contractor. So going back to that Dynamics slide, this was a sea change for California, and we understood that this is what Massachusetts is doing. So okay, California is doing it too. So fast forward, and in legislation, there's talk in Sacramento about how do we codify this decision, and of course, everyone with a lobbyist starts talking in Sacramento about we need an exemption from Dynamics. We need to be distinct from this ABC test. We have special circumstances. So in short, AB5 is enacted. AB5 has a lot of exceptions compared to the ABC test as decided in Dynamics. And this legislation, which takes effect this year, 2020, and which governs wage and hour, labor code issues, and is going to expand in its impact, is one that really has caused a lot of discussion and frankly further changes for reform in California. There's going to be efforts to perhaps modify exemptions or to provide additional exemptions from the ABC test. But long story short, California is learning to live with a three-factor test because of dynamics and AB5. And it's going to be a climate where it's very difficult to have a viable independent contractor relationship. And when you compare it to federal law, it almost makes federal law irrelevant in California, because whatever the board might be doing with Super Shuttle or the Uber advice memo, the reality of your day-to-day operations in California or states that have adopted the ABC test is you need to be mindful of these three factors. And if you don't fit them, for sure, you are taking on some significant risk in operating your business. Now, if you are an advocate for employees or a labor union, you are going to see this as a great opportunity to challenge those relationships, to perhaps seek leverage for organizing. And this is something that I spend a lot of time in my practice advising businesses. You need to be aware of this. And if you want to comply with the law, you need to be getting up to speed. You need to be modifying your relationships, perhaps documenting them in a new and different way so that you can be compliant and withstand attack.
I'm going to ask Josh to comment on these developments, but to do so in the context of the next one, which is litigation to enforce AB5. Josh?
So this is literally hot off the presses. We've also included the docket report for this case. So I want to start out by underscoring what Tom said. I mean, the sea change is, it's sort of like a tsunami. It happens so fast. I mean, we have the NLRB advice memo on Uber from April 16, 2019, and then a little over a year and a month later, on May 5, 2020, the Attorney General of the state of California filed suit against Uber and Lyft under AB5. And if you get a chance to look at the allegations of the complaint, you really get a sense that a sense of whiplash, where up is down and down is up, and how different this new this AB5 is from the traditional restatement test. And it's also interesting, though, as we're under this new standard, that the concept of entrepreneurial opportunity in the allegations is still a driving idea. This idea is not going to go away, even under the ABC test under AB5. And I want to read a couple of quotes from the complaint just to give you a sense of the difference in analysis for Uber from NLRB to this complaint. So what the complaint says about Uber is, it says, quote, the limited economic levers that each defendant leaves to its drivers, that means Uber and Lyft leaving to its drivers, such as whether to drive at busier times or for more hours, are not consistent with the level of decision-making normally exercised by entrepreneurs or those operating their own independent businesses. So this allegation is literally the opposite of the analysis of both intermodal and super shuttle. And there's another quote that I really like that I think illustrates the distinction, and some of this is just the framing, right, of someone working for a particular company versus working at large in a rideshare, or excuse me, in a transportation business. Here's another quote is, quote, when driving for each defendant, drivers are not engaged in their own transportation business, but are instead driving passengers and generating income for the respective defendant. So the starting place for this complaint, which is the opposite from a factual perspective, not just a legal perspective, from the NLRB's analysis, is when driving for each defendant, when driving for Lyft, when driving for Uber, as opposed to the NLRB, which really broadens the analysis beyond Uber to the economic possibilities of owning a car and having made the original entrepreneurial decision, according to NLRB, to provide a passenger service that only an individual can choose to make. This also means that, according to the complaint, owning your car is not a big deal because driving it is not a trade. And that, I think, has some interesting implications generally for tech gig, where we see some of what are more de-skilled professions, where they're whatever the nature of the service is, or low-skilled labor that is being accessed or harnessed or amplified by a particular application, where we have a statute now in California that says just because you're working for an application doesn't mean that, suddenly that becomes a business or trade. And it's also interesting in the passenger business in particular to think about this from a historical perspective, because it's not entirely right. From a historical perspective, providing rides to others and to yourself, those two things have coexisted as both a trade and a personal activity for a long time in the taxi business. So very interesting lawsuit. And I think as Tom indicated, it's going to be much harder for Uber and Lyft to satisfy the ABC test. It seems unlikely they'd be able to, as opposed to the restatement, which leads us to the opposite conclusion.
So with that, I want to move on and discuss development number 9. There's a lot of litigation involving Uber and Lyft and other ride-sharing companies all across the country. This case stood out as combining, not only being recent, but combining the arbitration waiver or the arbitration pre-dispute agreement issue, the class action waiver issue, and it's a wage and hour case, Cunningham versus Lyft. And the federal district court there has issued a couple of decisions that weren't published, but you can find it in a PDF if you put in this information online. The second half of what's in the parenthetical there is the first piece of interesting news. In an earlier motion made by Lyft to compel arbitration of a class action that was brought by workers who wanted to get minimum wage and overtime benefits, the district judge denied the motion to compel on the grounds that the drivers were entitled to invoke the transportation worker exception under the Federal Arbitration Act, meaning that they could not be compelled to arbitrate their claims even if there was an agreement to do so. And the other developments that came out of this case were, well, Lyft is taking an appeal, and so they brought an emergency motion to stay the effectiveness of the judge's earlier decision pending the appeal, and the district judge said no to that. And then on the other side, the plaintiff class filed a motion for an emergency preliminary injunction to enjoin Lyft from continuing to misclassify drivers as independent contractors, but they denied that too. So I guess the good news for lawyers is that there's a full employment litigating these issues, and there'll be plenty of opportunity to do it on appeal as well as in the trial courts. I don't know if either of you wanted to add anything to that before we moved on to the last development. Okay, so let's wrap up the developments and then we'll move into talking about the future. On slide number 19, we wanted to note here that not everything that's occurring that's involved in this cutting edge issue is taking place in California. And there, in fact, has been significant pushback in other states who are resisting the trend toward ABC or what is happening in California. And so in 2016, Arizona passed a law that classified many gig workers, including rideshare drivers, as independent contractors. And in 2018, at least 5 states, Florida, Indiana, Iowa, Kentucky, and Tennessee, all passed legislation that classified certain on-demand workers, which could include rideshare drivers, as independent contractors. And then just last year, Arkansas codified the 20-part test used by the IRS to establish the right to control and to establish an employment relationship that we mentioned earlier on slide 9. So not everyone's going in the same direction on this, and it may very well be that depending on the region of the country you're in, you have to comply with radically different versions of the law in the same area. So with that, I wanted to move on to talking about thoughts about the future and ask the panelists if they wanted to comment on that are up here. The first one being that there's been pushback by employers. Gig companies are complaining of lost flexibility and increased costs and are supporting litigation and ballot measures to repeal or modify the ABC laws. Gang, would you like to jump in on that?
I think employers are going to be looking to lobby as hard as they can for favorable legislation, favorable regulations that will enable them to preserve their business models. I think that is one of the biggest concerns I've heard from different businesses and different industries is they're trying to force me to change what works. And what we've been doing for years, for decades, and this is going to be a survival issue for us. And so if they can't modify the test to protect their business model, they're going to be seeking exemptions from whatever the rules will be. And litigation will be probably a last resort. If they haven't been able to make effective change to whatever the tide brings, they will seek some sort of relief through the courts to say that they do not have to comply with new different heightened standards that impact business as usual.
Josh?
So from the employee and labor union perspective, I think that the general sense is this is while it's still a relatively small part of the economy, this is the slippery slope to potentially more part-time work, fewer benefits, lower wages, and more independent contractor status. So I think that the employee advocates and unions are very focused on limiting this absolutely as much as possible. But one of the interesting things, as indicated by Chris's slide, is that there are pushback by workers also. There will always be a really significant portion of the labor pool that really wants a variable workday and doesn't need the benefits or finds the income to be supplemental in some way. And so despite, I think, an ongoing push by unions and employee advocates and their lobbyists, there's still going to be a labor pool that really wants this work. And I think that you're going to find that there is, or that my clients are going to find that there is wide enough appeal, not just from the particular workers who want this work, but the synergy that develops for this to be an ongoing part of the economy, particularly as we see more and more automation of jobs and there being more de-skilled professions, which previously were skilled.
I just want to point out under the pushback by workers, there's no unanimity of view among people who are doing the labor here. And sometimes it depends on their socioeconomic status or the particular profession or trade that they're engaged in. People who are working in higher end, high status jobs as consultants in IT, showrunners in Hollywood, lawyers that are freelancing, court reporters may be very happy with how things are going. And I have, for example, in any number of arbitrations, had court reporters pull me aside and say they're concerned that they're looking more like employees, and what they really want to do is to set their own schedule, take their own gigs when they come up, and don't want to be considered employees. On the other hand, folks who may be working in landscaping or who may be working on a contract basis in a nursing home would rather have the benefits of being an employee. So it depends on who you're talking to, what they do, and in many cases, their professional or educational status and what part of the country that they're in. One development that I thought was interesting, and I think in the bibliography we have a citation to the article where it appeared, is that during the COVID-19 crisis, when so many people are out of work or have to come up with some way of working from home, a number of folks working in IT, freelance journalists, et cetera, are complaining that they can't get work with companies that are based outside of California because those companies are worried if they hire a California-based worker that they're going to have to treat them as an employee under the ABC test. And so people are concerned about not having jobs. And that's something I hadn't thought about until I read that.
Yeah, I think that the freelance issue is a really interesting one in light of AB5. And as I recall, the number is 35 for the articles, gigs as such. that someone would be responsible for. They would be an independent contractor to the extent they wrote 34 articles as a freelancer. But once you hit 35, you're suddenly an employee of that entity for which you're providing services. So freelancers have been among the more outspoken people in California in terms of seeking reform, seeking amendment to the statute, AB 5. I think, you know, we're going to continue to see development like this. But in the meantime, I think that this is perhaps a great organizing tool for labor to look for opportunities with businesses that rely on the independent contractor or so-called independent contractor model.
Josh, anything to add there?
No, thanks. I agree with Tom.
Up till now, what we've been talking about here in terms of pushback by employers and workers is the present. The future always throws a few twists and turns at us. I've seen some talk about looking for a third way to do it, but up to now, most of the actual proposals, ballot measures, there's one right now that the Secretary of State in California is considering that's been promoted by Uber, Lyft, Postmates, and some other companies to repeal all or part of AB 5, are more of an all or nothing situation. And so looking for the so-called third way where gig companies and freelancers or would-be independent contractors or employees are each getting something that they want out of it. I haven't seen too much of that, but I'm looking for creative ideas to emerge in that area. We have a couple minutes here, and so if we have any questions, we'll be happy to entertain them at this time. Anyone out there? I'm monitoring the participant list. I'm not seeing any hands up. And if there are none, I don't know if we have...
we have some questions on the chat, Chris.
Oh, look at the... Okay, I've been looking at the hands, not the chat. So
let's see. I can read through the questions. One here is, for those of us outside of California, what are the prospects of the Uber-financed ballot initiative?
I think it's hard to say. My crystal ball is broken, so I never know how things are going to go. Was surprised after many years of hearing freelancers like musicians, for example, complain that they didn't have the benefits of employment, to hear folks agree with the ride-sharing services, for example, that they'd rather not be independent contractors. I guess there's a real chance that ballot measure, if it's approved by the Secretary of State, we have all kinds of rules in California for that. I suppose it could pass. It's hard to know. California is a blue state, but this is an issue that affects people in their pocketbook, and so there might be some other folks out there. I saw Ken Jacobs was out there in the audience. Maybe Ken's got a view about that, but I'm not really sure what'll happen. It'll be very interesting to see if it winds up on the November ballot.
Yeah, I would, as far as as far as I can tell, it's an open question, and there's just so much attention on California right now, who's to say if it fails in California whether they might try something in another state. I think if they can build some leverage somewhere, they're going to want to invest their resources to try to do that.
Yeah, I agree with both of you, Tom and Chris. And I think that, one of the X factors here is that I think people really like using Uber and Lyft. And so it's not going to be determined by the employees or their advocates or the employers and their advocates, but the fact that we have a service that a lot of people really like. And going back to the old model of just taxi companies, even if that's not a fair comparison as to what things would look like, is not something that appeals to a lot of people. So I think it's a real open question.
Yeah, I would say, modify what I said about the third way approach. We actually have an example of that in the CARES Act. The pandemic unemployment assistance made available for the first time I'm aware of in any official way, unemployment benefits to gig workers. And as I reported earlier at the beginning, as many as 36% of all the claims filed nationally are by gig workers. So even folks who I think would prefer this as a work model, many of them, at least in California and maybe other places too, are interested in having some of the benefits that go along with the traditional payroll employment model. And right now what we had is an ad hoc approach to that in the CARES Act. Maybe something more permanent will take place, but my guess is that that would be at a state or local level rather than the federal level, at least for the foreseeable future.
And as I recall, also in terms of a third way, the city of Seattle enacted an ordinance to allow rideshare drivers to organize a labor union, and
Right.
that would be a way to try to deal with this misclassification issue and to give them some rights to engage in concerted and collective activity. So I wouldn't be surprised to see similar efforts elsewhere. But of course, I would expect that the companies would challenge any such rules, as I know they resisted the effort in Seattle as well. We do have another question on the chat. Do you see any jurisdictions adopting a third and middle classification of what some call the dependent contractor? In any event, is that something you'd recommend or caution against?
Well, where I've seen the dependent contractor classification used is in some provinces in Canada. I believe, I may get this wrong, Saskatchewan, and I think one other jurisdiction use that characterization. The purpose of that is to distinguish between the independent contractors that are perhaps at the higher end of the food chain, professionals and consultants and the like, people that have bargaining power based on their skills and education and ability, who can have more influence over the terms of their gig, versus, for example, FedEx drivers, who my understanding is that what they do is regulated down to what their shoes and socks look like, but it's on a take it or leave it basis. So exactly how it works, I'm not familiar with the details of that, but if somebody wants to send me an email, I can provide you citation to a couple statutes I'm familiar with in jurisdictions where that terminology is used.
I think it's a fascinating idea, and I recall looking at the economic realities test a few years back and thinking, that was really the direction it was going. If you are reliant upon a particular entity, a particular business for your livelihood, it's really in sort of a third zone. But if you have really a bifurcated view of things, if it's either fish or fowl, employee or independent contractor, I think the current standards would be such that you're going to be misclassified, particularly with developments in California. So yeah, I think it's an interesting idea, and if you have gig workers as well as businesses in a place where they have the ability to voice a need for this third sort of category, yeah, perhaps it will be viable. I don't know that it'll be California, but perhaps elsewhere.
I guess I would just add to that some of this is an academic discussion depending on the jurisdiction you're in. The more categories you have, the more factors involved in a legal test, the more expensive, the more costly the litigation is for workers to bring. And so it almost, I think in some jurisdictions, it doesn't matter what the law says if it's not economically enforced. And so to the extent that organized labor sees this as an opportunity to organize and provide support to enforce workers' rights, it's going to be more effective. To the extent that it takes place in a jurisdiction where you don't have access to that kind of thing, it's tougher. So for example, in a jurisdiction in which not only do you have mandatory pre-employment arbitration agreements being enforced, but also the class action waiver that basically forces an employee to bring an individual claim, and it's going to be more expensive to litigate that than it would be if they could join with other people in a class action. In a state like California, we have a statute called the Private Attorney General's Act, which allows a single worker to act as sort of a bounty hunter to bring an action on behalf of herself, but also to benefit other similarly situated workers, and part of the recovery goes to the state. But there's an incentive for plaintiffs and their attorneys to bring the litigation, and it's done outside the restrictions of mandatory arbitration and class action waivers. And that's not true in most states. And so therefore, I'm not sure in some ways that reform legislation, if that's what you want to call it, will change very much if it's still the burden of litigating is put on the individual worker.
We are at 9:16, so that puts us at time. And want to thank everybody on the panel, and thank everyone in the audience for participating.
Thanks all.
Thanks, everybody. Take care.
Have a good day and enjoy the conference.